number 202, the people of the state of New York versus Anthony Perkins. Good afternoon, counsel.
May it please the court, I'd like to reserve 2 minutes of my time for rebuttal, please.
You may, sir.
It's Stephen Younger for appellant Anthony Perkins. This appeal concerns a serious legal error that was made by the suppression court. It's a case where all of the witnesses were shown a photo array with people having nothing but dreadlocks, that's A1065, and then put in a lineup with people who was the only one with dreadlocks.
Is that an argument that was made to the trial court, counsel?
Yeah, this is preserved. If you look at
Suppression
page RA5, which is attached to the people's brief, it's the brief that was submitted to the suppression court. The tie between the photo array and the lineup was expressly argued by defense counsel before the suppression court, said that that resulted in simply a confirmation of what had happened in the photo array, and particularly pointed to the fact that the witnesses were told that the person you picked out of the photo array is going to be in the lineup, drawing that connection for them, and that was put before them. And regardless, there's a legal question here. The legal issue is, what is the totality of the circumstances? That's what the test is under due process. And in this case, the court cut out of the analysis a whole range of issues, a whole range of circumstances. The only thing the court would look at, they said it has
Have
no...
we adopted that rule? That's not our rule, right?
Well, it's a very interesting line of case that you have to follow. It is your rule as a minimum threshold for due process for lineups. You've adopted a per se rule for show-ups, you know, throwing out in many of the cases that rule, coming up with a tighter rule. But you still have to meet the Supreme Court standard in Brathwaite, which is totality of the circumstances. You can't fall below it. So what does the court say? It says, we're only going to look at a very small snapshot. It has no legal significance that this person was the only one in the lineup. Why? Because all we're going to look at is what was told to the police. Now, that has a lot of grave consequences because it can happen in a 2 to 3 second encounter, as we have here. You don't remember everything. It can happen in a 911 call, which is under very extreme emotional circumstances that we have here.
If you look at it, not tautologically, but the victims describe who they believe to be the perpetrator, and they don't mention here. They don't mention dreadlocks.
Well, 2 out of the 4 at least, and I believe 3 out of the 4 do.
Well, let's assume. All right, I'll take the one.
Okay, one of them then.
Now they pick them out of the photo array. If they had stopped there, if the police had stopped there, you wouldn't be here, right?
And nor would we have a conviction because the folks who didn't have a lineup acquitted.
Then when they go to the lineup to, let's assume, confirm what they saw in the photo array, and they pick out the same person, you're saying that that's a denial of due process because he had dreadlocks that they tried to cover up in the lineup, right?
Actually, something quite different. The court found that this was a unique physical attribute of my client that made him stand out, including with the hat. In fact, I think the hat...
That was only as to 2 individuals.
As to 2. So there's no argument here that the hat covered it up. In fact, that distinguishes it from the case that they cite Kirby.
What struck me was that let's assume a wholly different case, but there's a description of the perpetrator. There's a lineup, and the person who they think did it, they now recall had a scar on his forehead, and the only person with a scar on his forehead is the one they pick out. Now, the police don't know that, and that's, I think, what the court was relying on, saying nobody talked hair. And so, you know, what the police did here was exactly what they should have done in terms of...
And respectfully, that kind of analysis can't apply to a pattern case. We don't have a single one-off case where most of the cases they rely on are single one-off cases. Here you have police who are investigating a pattern where 2, and now it looks like 3 because of difficulty in language, people say the person who robbed me had dreadlocks. So the police know. It's not a question of, in fact, if you look at the testimony, the police officer said he put the defendant's photo into a computer, and this was spit out by the computer. So and he testified that was because of the description. So that is what it's not a case where the police aren't looking for someone with a scar.
But the description is not dreadlocks, right?
The description of Baden-Posniak is clearly dreadlocks, and at trial, Bukowicz said, I told them long hair and dreads, but I don't know the word for dreads in Polish. Okay. So there was a difficulty, which is part of the reason you can't just look at what the victims told the police, because there can be communication issues.
Aren't you also saying that because they set up the photo array in the way that they did, they obviously knew that the dreadlocks were a distinctive feature?
More than obviously, that was the detective's testimony. The detective's testimony was that he put this into a computer, and these lineups are generated based on the description. The description had to then include dreadlocks, so you wouldn't come up with all these guys wearing dreadlocks.
Well,
What could they have done?
There's several things. First, which is done very commonly, in the photo array, you could have photoshopped the dreadlocks out. So with the people who didn't mention dreadlocks, you're not sticking that idea in their mind. But I think more importantly, at the lineup, which is what we're really focusing on, 3 of the witnesses said this defendant was wearing a hoodie. And including the witness who said that she didn't really see the hair. So if you wore a hoodie, as they said they virtually all saw him, you wouldn't have seen this, as opposed to a hat, which if you see in the photos, it's sticking up here and everything's sticking right out. I don't think it's our job to sit there and second guess and say you could have done this, you could have done this. The point is they had 3 weeks to do this lineup. It's not a case of an exigent circumstance. They waited 3 weeks. In fact, they waited 3 months to indict my client. So they had plenty of time to find people who wore dreadlocks, but if you couldn't, there are other ways that could have covered up. And I think the real question is what's the policy here, which is that we want to avoid the risk of misidentification. And by doing that, you can't just look at a very narrow snapshot. Totality of circumstances is everything that went on.
Counsel, let me
That's the
just...
rule. I'm sorry, that's the rule that you would propose, that it be totality of the circumstances, not if the victim or complaining witness says it's a distinctive feature, or it's a feature that
The
they
police
remember.
description is part of it. So, for example, if I tell the police I just saw someone running out with a red jacket, someone else may not have seen that red jacket. And that, by only putting someone with a red jacket on makes it distinctive as to me, may not make it distinctive as to somebody else. But I think the rule here is when you look at the totality of the circumstances, you can't say the only thing I'm looking at is the police description, that everything else is legally insignificant.
Yeah, and my question goes to that. So let's say you have you didn't have the photo array here, and you just had these lineups. Suggestive or not suggestive?
I think we'd have a different case. It would be a much, more difficult case. The difficulty is you'd still have the suppression court's finding that was a distinctive feature enough to make it suggestive to 2 people.
And what what interests me in that way of looking at it is there has to be a certain amount of objectivity in this type of feature, right? I mean,
Agreed.
It can't all depend on a witness statement. I mean, isn't there something that you look at this, because as you're saying, what you want to ensure is that this is a reliable way of making an identification, right? So if there's one person with a startlingly different physical characteristic and you think that's the person that did it, what's the obligation there then?
I mean, if you put me in a lineup with 5 bald guys, I have no doubt that I'd be the guy that sticks out like a sore thumb.
Can they just look at this in the fact-finding court and say, looks fine to me?
Actually, no. The suppression court found it wasn't fine. The suppression court found there was a unique feature that was unduly suggestive, based not just on that, but also on the testimony.
Yeah.
Mr. Younger, do you care to move on to the Batson issue?
Yeah, could I, the Batson issue or the 911 tape?
Batson issue.
Okay.
Well, actually, your preference.
I'd first, if I just briefly talk about the tape issue, that's a case which I think is controlled by this court's decision in Handy. It's virtually no different.
Talking about Deshaun Andy, the videotape in the prison?
Correct.
Right.
You have a situation where the government's policy results in the elimination of evidence,
Yeah, I
Not
think that- I think
negligently,
there
but
was
intentionally.
I think there they destroyed the tapes within 30 days, and
And
here
here's
it's
90
90.
days.
And
Right.
wasn't that Brady, not Rosario? Doesn't that make a difference?
It doesn't, because actually in Handy, it was just pure evidence law. The pattern jury instructions, that's what this court relied on. It's been the law in this state forever. Evidence is intentionally destroyed to get an adverse inference. And what they're saying, we're talking about a lesser sanction than dismissal. It wasn't, dealing with Rosario issues. The argument my adversary is making is, well, you need prejudice. Well, this court said, no, you don't have to have prejudice if it's simply an intentional destruction as opposed to negligent. I'm sorry.
You may.
I was just going to ask in terms of, in Handy, I don't know if there was an issue about how you store these things or how many. I mean, 911 calls come in, I don't know, there must be 1,000 already today, 911 calls. So where are they supposed to store this stuff?
I want to make it clear, I'm not arguing the NYPD policy. In fact, they've lengthened it now. That's not the issue. The question is, do you get an adverse inference? You could say the same thing about prisons. I mean, there are cameras all over the place that are running 24/7. It's not a question of burden. And, in this day of digital storage, you can store things longer than 90 days. You're not running over a magnetic tape. But our argument is simply, pure evidence law that you're entitled to an adverse inference. So on both the suggestive lineup and the 911 tape, we would ask for a reversal as to Bukowicz, who wasn't able to identify anybody at trial, and a remand as to Hung. Thank you.
Thank you. Counsel?
Good afternoon. May it please the court, my name is Nancy Talcott from the Office of Richard A. Brown, the District Attorney of Queens County, representing the respondent in this matter. This does involve a mixed question of law and fact, and there's ample record support, and that's the standard before this court. Is there ample record support for the hearing court's determination, which was left undisturbed by the appellate division, that the lineup was non-suggestive as to the witnesses who did not describe the robber's hair to the police?
Can we
Can you
get
tell
to
me
that
what
point?
these are?
I think that might be the back to show you that those were the exhibits. We put stickers on the exhibits. So-
These are the backs of 1076,
I think so,
for example?
yeah.
But to get to the point on
Mystery sound.
objective versus subjective, so when does it become a point where the lineup is so suggestive that you don't have to look at what the witness told you? Because going back to Mr. Younger's point, if you suspect someone of being the person who's committed this crime, if you put them in a lineup, you are supposed to, I think, to make this a valid identifying procedure, have some differences that would make it, you rely on this identification. So if the witnesses aren't telling you it's an African-American, and you arrest an African-American for the crime and you put him in a lineup with 5 Caucasians, I think we could all agree that would be suggestive.
Exactly.
Even though you don't say, well, the witness didn't tell me he was an African-American. So where do you draw that line?
It doesn't always hinge on what the witnesses said, but here, when you have an otherwise fair lineup, if you look at the photos, and we submitted the side views, because that
But here
shows...
it seems like the court did hinge it only on that, because for 2 of the victims who mentioned the dreadlocks, it was unduly suggestive as to them, and for 2 of the victims who didn't, it was not unduly suggestive. So how can that not be, based on a wrong standard if we say that's not the standard and that's not the only factor?
Because in an attempt to make this a question of law, when it's really a question of law and fact, the defendant characterized the court's decision as such. When you read the court's decision in its entirety, it's clear. It actually stated twice on page A10 and A12 that it was using a totality of circumstances standard. It references that same standard on page A27. The court did not just rely on the sole fact that the description didn't refer to the perpetrator having dreadlocks.
But to follow up, like, on what Judge Garcia was asking, and I think this is part and parcel of the defense's argument, if you have the lineup, got it, we can argue one way or the other. If you have the show-up, or the photos, got it, you can argue one way or the other. But when the photos tip off, my word, nobody else's, as to who the perpetrator is, and then you move that perpetrator into the lineup, doesn't that taint it?
Well, just as an initial matter, before I get to the merits of that, this particular novel issue is completely unpreserved for appellate review. It was not raised in the court, and it was not addressed by the court. The argument with respect to the photo arrays, and then linking it, the photo arrays tainted the subsequent lineup. The underlying arguments attacking those, with regard to Bookowitz, it had to do with what Detective Kramer said to her. He didn't remember. It also had to do with so it might have been suggestive. Also, she used an interpreter. Maybe it wasn't interpreted properly. And the distinctive factor they pointed out attacking the photo arrays and then trying to link that to the lineup was the fact that she said he wore a dark sweatshirt. Nothing was raised with respect to the hair or that all the photo array participants had dreadlocks.
Getting back to the totality of the circumstances, what circumstances were different among the 4 victims other than that 2 had mentioned the dreadlocks and 2 hadn't? So even if the court said that's what they were doing, what circumstances were different amongst those 2 sets of victims?
Well, other circumstances were the same, and the court looked at the lineup and noted all the other similar characteristics. They noted the fillers were not glaringly dissimilar.
I understand that, but...
Oh, vis-a-vis the 2 and the 2?
Yes, exactly.
I think that was the main distinction. There might have been height discrepancies. I don't recall each
Okay,
particular.
so the distinguishing factor then for this court was, for the suppression court, was whether they had mentioned it or hadn't mentioned it to the police. And if we say that that is not a distinguishing factor, or the distinguishing factor, then how can we differentiate?
Well, you can say with respect to those 2, one said dreadlocks, one said long hair. He didn't even say dreadlocks.
But if we're
but it's
saying
still-
that
No, you're
that
not.
is not a valid basis for saying this is not unduly suggestive, if we're saying that you can't just rely on what the witness told you, my hypothetical, I didn't say it was an African-American, but that's the only one in the lineup, you can't rely on that. So what is your basis for saying this is not unduly suggestive as to these others when the court relied solely on the fact, it appears from the record, that they hadn't said it in their description? Because otherwise it would be unduly suggestive if they had said it. So,
Well, no, because the case is made clear that it does matter whether the witness had said it. Rahim makes that clear. The principal question is not whether there was a distinguishing
well, there
feature.
might be a difference, though, don't you think, that if somebody says the person who committed this crime had a Harvard sweatshirt on, and I've got a lineup that I can just look at objectively. One guy has a Harvard sweatshirt on, and boy, that doesn't, they all look physically kind of alike. But if I look at this lineup, I can say objectively, one of these things does not look like the other, and a distinctive physical characteristic. Isn't that a little bit different than the Harvard sweatshirt?
I think it depends on the circumstances. I think you can have an obviously improper lineup without any input from any witness. Just like you said, you know, we think it's a white guy, and we arrest this guy not having any input from any witnesses. We bring in a
Right.
witness who hasn't given a description, and he's with 4 African Americans.
So there
You
has
might-
to be
You might be able to
some
tell that
level-
on its face.
Right, so there has to be some level of objective fairness, let's call it the wrong word, but to the lineup, right, to make it not unduly suggestive. So the question I think we're struggling with is, where is that line in a characteristic like the one we're talking about now, as opposed to maybe an article of clothing that would be innocuous in another case?
Well, I think the court did that. I think its initial findings, they found overall, this lineup is okay. They have the same facial hair, they have the same skin coloring, they have the same physical characteristics. Nothing really singled him out. The fillers aren't glaringly dissimilar. There's no evidence that the manner in conducting the lineup was improper. He did go through other things. So then it came down, so there was an objective assessment of the lineup in general.
But it came down to the hair again, counsel. You know.
That was one factor that rendered it impermissible as to those 2 who had mentioned it.
No, not just those 2, and that's what I wanted to bring up, because one of the witnesses who didn't mention hair to the police officer, or at least it wasn't recorded, then in court, and picked this man out of a lineup and out of the photo array, then in court says, but I also noticed he had long hair. So the witness never told, at least on this record, it appears that the witness never told the police that the perpetrator had long hair, but she mentioned that at trial, so it must have been something that she was thinking about because it was important enough for her to say it at trial. So you have this unstated distinctive feature that was distinctive to that witness, yet she picked him out of the lineup.
Well, and again, maybe it was a language barrier. Initially, it wasn't really clear whether she said it, because Detective Kramer said she hadn't discussed the lineup. And at some point after she said she described the hair as curly, if anything, and then she said, I don't really know what I said when I talked to so many people and gave different descriptions. Now, when they moved to reopen the hearing, which isn't before this court, and the appellate division affirmed, they said those new facts proffered were unlikely to affect the original determination. So it's not at all clear, just because she said hair, that would have resulted in the same conclusion of the hearing court.
I think she said long hair, which would be different than hair. Because the dreads
That came later, but initially she said curly, which interestingly, the defense attorney in the hearing, that's how she described all the participants' hair. She said, they all had curly hair, but defendants stood out. So it's not that clear, and the court, and that's a factual finding that the lower court found and the appellate division affirmed, and there's record support for that. And that she may not even have said anything to the cop, because Detective Kramer testified that she hadn't said anything.
So I just want to be clear, are you saying that the rule that you would request us to adopt would be if the complaining witness or the victim testifies or says something about a physical feature, that might be unduly suggestive, but if they don't, it's not?
It may, because we're also looking, again, her subsequent testimony indicates she may or may not have told the officer that the police conduct was no better or worse. And that's why it wouldn't retroactively negate the propriety of the lineup with respect to her. Because we are looking at the police conduct here in
Can I just
formulating the lineup.
your time's almost up, and I just wanted to ask you briefly about the 911 tapes. What's a sprint report?
A sprint report,
Take your time, go ahead. I don't mean that.
it's a simultaneous memorialization of the
Is it a transcript
call.
of the recording, or is it just a name and what time they called?
No, it documents what they actually say.
I see.
And, there's an incentive for its accuracy, because this is what's being then relayed to the police.
Well, who writes it?
Then I think the 911 operator promulgates it. But again,
operator.
we could have admitted this evidence, concerning the background and the accuracy and the checking
So
of
it's
the sprint
basically
reports
the
had it been raised
operator,
below.
it's basically the operator's notes as to what he or she heard.
That's my understanding, but again,
I'm the operator, I take the call, and then after the call is done, I take notes? Or am I taking it
no, it's on
simultaneously?
simultaneous, real time.
what I
yes,
write from what I
yes,
hear.
Yes.
Okay.
But again, a lot of that evidence could have been put forth regarding sprint reports in general had this issue been raised. The general attack on the police policy was never raised
Your
below.
time ran out. Do you want to say anything quickly about Batson?
About the Batson issue.
Yes. Like 30
Again, this is a factual finding, which this court has set forth that should be afforded great deference. And the court made clear, the prosecutor said, she didn't have a good rapport with certain jurors. She also expanded on that with respect to at least two regarding employment. Now, you don't have to agree with the employment. Some might stem from stereotypes. The court doesn't have
How
to
does the
agree.
court review that rapport? I mean,
It's very hard to, and I think the court made note of that. Whatever it had seen, it said, this is based on my observation of these courtroom dynamics. Whatever he saw, he said, if the prosecutor says this, and I make a factual determination that her reasoning is not pretextual, that's my factual determination. He specifically said that. That was his factual determination. Based on what she said, based on his own observations, and he didn't really get the employment things, but he doesn't have to. All he has to find was that it's not pretextual. Somebody might remind somebody of their second-grade teacher who was horrible. Well, a judge might not agree with that or understand it. He might think it's silly.
What about the woman who was, whose occupation was the mortician, where there were no questions asked of her?
Again, employment, whether it seems logical or not, whether it's related to the facts of the case or not, can still be deemed non-pretextual. And she actually did posit a reason, although I don't think she articulated it fully. The judge said, well, do you have a dead person here? And she said, no. That's exactly why I'm precluding her, because you have people who weren't even physically hurt.
Doesn't your
apologize.
approach, though, allow, not you, of course, allow a perhaps not such a well-intentioned prosecutor to come up with any excuse, no matter how, as even this judge says, these sound not logical to me in terms of the employment. Doesn't seem to make any sense to me, but it's a peremptory. You get to do that if you want. So at what point does it tip from, yes, of course you get a peremptory, unless the defendant has made that, passed the first step of Batson, you don't have to explain it, but at what point does it tip to these explanations now, in context, perhaps individually, they don't show animus, or they don't show discriminatory intent, or they don't otherwise show a pattern, but taken together, there's a problem. When does that tip?
Well, it tips when the trial court who's there actually viewing, and that's why this court has stated it really has to be afforded great deference, because it really comes down to the court's
question is
credibility determination of the prosecutor or the party defending the strikes.
What I'm hearing you say is that it can almost never be overturned, though.
This court has rarely overturned a Step 3 Batson challenge.
When
I
could
will
it be
say that.
overturned? How, give me an example.
I guess if it was blatant and it just defied reason, the record, I can't think of an example.
I mean, but here's what I want to ask you. I understand your argument about the factual determination, certainly what the judge says more than once. This is my factual determination based on what I think the prosecutor believes, based on these dynamics. But isn't in part the possibility to create the dynamics is within the control of the prosecutor? I mean, on one of these, he says, I didn't even ask her anything, but I have no rapport with her. I mean, how can you determine rapport when the prosecutor is able to control the opportunity to ask questions to see if there is a rapport?
They are limited in some respect because of the time constraints. So based on perhaps questions, and again, it's not just questions she gave to the entire panel. She's also viewing the questions the court asked the entire panel and the questions that the defense attorney asked the entire panel. So she may not have chosen to use her time asking that particular witness.
I'll tell you what's difficult is to see whether or not there's no rapport with someone who's not of this racial group, because that record's hard to place. And that's what I'm saying about the opportunity that prosecutor has to control the creation of a reason that sounds not in violation of Batson, and the opportunity to not allow the record to be so clear.
Well, I think she did try to make a record. I'm not so sure it was as complete with respect to the employment, and she did offer the alternative reasons in addition to rapport with respect to at least the two. The third one, actually, I think there was some question as to her ethnic background. They are limited in their ability to make a record, and defendant
the
didn't
Chief
refute
Judge's
the court's
permission.
findings.
Yes.
I just wanted to ask, counsel, because you answered the question regarding the destruction of the 911 tapes as if the defendant is challenging the NYPD's policy, but that's not what they're saying. They're saying it's just a purely evidentiary issue, that evidence was destroyed and they're entitled to an adverse inference charge. And what's your position?
This is Rosario. So in Martinez, the second Martinez, this court found non-willful, non-negligent destruction of Rosario. You have to show prejudice. Not only did he not show prejudice, he didn't even allege it with respect to Hung. And that's the person whose call is at issue here. And there is no fair reading of the record that he wasn't only exclusively referring to Bat. He actually says, in this particular case, Mr. Bat's case. It's clear he didn't allege, let alone show, any claim of prejudice with respect to Hung. And even under the Handy standard, and there's no claim that the evidence destroyed in handy, which could have implicated the officer who destroyed it, can be equated with the 911 call. They had the Sprint report, the witness herself testified, and you had police reports documenting. So he was able to establish any prejudice, but there was none.
Thank you, counsel.
Thank you.
Mr. Younger, how does defense counsel go about establishing his or her burden on pretext in the Batson context? Of course, if the prosecutor's alleging, I didn't have a rapport with these women.
So let me talk about how it happened in this case. In this case, there are 4 peremptory challenges to the 4th, and the court found they were all female African Americans. The court said, you have raised a prima facie case. So now defense has made their case, the burden shifts, always have the burden on the defense, but the burden shifts to the people. What do they say first? 2 employment-based reasons. Sister of an immigration attorney, mortician. The judge says that's illogical. It's a non sequitur. There's nobody dead here. In fact, with an immigration lawyer, they would more likely sympathize to you, because these victims are, people of diverse backgrounds, than to the defense.
But that isn't unusual in jury selection. I
know. I agree.
It's not. Well, lawyers all the time say, don't want any engineers on a personal
I can understand
injury
that, but
jury.
here's what's critical here. The prosecutor then shifts. The prosecutor gives up the employment-based reasons and shifts to rapport. That, to me, is a sign that this is a pretext, right? I gave you some reasons. Well, that's not my real reasons. My real reasons are rapport. With one, I didn't even talk to the person. I saw you at a cocktail party. I never talked to you. I didn't have a rapport. There's no basis in the record for that finding. The prosecutor's just shifted, but more importantly, what the prosecutor said about rapport was contradicted by the record. The prosecutor said, I asked them several questions, and I didn't get. They asked one question of each of the other 3 people.
Well, the judge made findings. Was the standard that he applied in making those standards the appropriate one in your view?
You're absolutely correct. The judge made findings, but if you try to dissect through what those findings were, he basically threw everything up. Well, it could be this, it could be that, it could be this, and there's no specific finding, nor is there a record basis to say that there was actually a lack of either rapport or there was some basis for an employment-based challenge in the case.
So is your argument that it's pretext, despite, for 2 of them, identifying employment, and because at some point the prosecutor, after going through this, says, Your Honor, I didn't feel a rapport with these people that I preempted during my jury selection. That's why I preempted them,
Right.
including the fact that she's a mortician. I had absolutely no rapport with her. And then goes back to the individualized.
Exactly.
It's those 2 couple of sentences where
Exactly.
after doing some individualized
Right.
discussion, the prosecutor comes back and says, I just didn't have rapport with any of them, and I've got these individual issues.
Yeah, exactly.
I mean, but it is possible, certainly, right?
Yeah.
In addition to the individual reasons that the prosecutor doesn't have a rapport. What about yes.
But
what
then
about,
you would expect the judge to put something on the record that,
But why isn't that on the
supports-
record when the judge says, look, it's hard to put it into a transcript, it's my view of the dynamics, it's my understanding and my factual finding about what this prosecutor believes.
For example, the witness for whom she'd asked no questions, despite saying she asked several questions, she could have said, I saw you looking at juror X, and I saw there was, no body language, or something specific you can point to the record, not just saying, rapport, I'm done. Could I just close with one point, because I think it's critical on the lineup what Bukowicz testified to. And if you look at A698 to 99, she first said, and this is what she told the police, she said, not just what she saw, that he had curly hair. She then on 699 says, that's what we call it, dreads. So she used the word dreads, but she used it in Polish, and that's exactly the point. If you have a witness who doesn't speak English as a first language, communicating through a translator, you can't say that's the only thing that you rely on. But much more importantly, if you look at A990, the prosecutor in the summation told the jury to rely on that identification. Why? Because Bukowicz saw dreads. How can you, as a prosecutor, say, doesn't matter, not in the police ID, because they didn't see dreads, and then in your summation tell the jury, that's why you should rule in my favor? Thank you
Thank you,
very
sir.
much.